No, I know, just most places have adjusted to the fact we are now in the level 1, but clearly not the judges.
Please, the court, your lordships, I appear for the first respondent. I'm instructed by the government attorney.
Thank you so much. Yes, Mr. Gonda.
Thank you, Deputy Chief Justice. Deputy Chief Justice, the actual ambit of the appeal we submit is narrow, starkly so. We submit that there are two real questions which arise. The first is whether the court below was right to dismiss the review of the minister's taken decision, which, and this is important for what follows, was taken as a matter of pleading and of fact, exclusively in terms of Section 63 of the Act. And if, on one or more of the three essential, as it were, subgrounds, the decision was not validly taken, we submit that's an end to the matter. A second component is the invoking of Section 30TI of the Act to the extent that it is by the minister and what the court is to make of it. But my lords, with your leave, we'll take our heads of argument as a written argument which stand and which we know, knowing my lords well, that my lords would have read attentively and my lords will have reference to again. So for that reason, my silence on any one or more point in the heads is not to be taken as any kind of implicit abandonment. I would rather focus on what seems very shortly to be the core of the matter. So too, it's unnecessary to rehearse the factual background. What is of importance for what the court does is the fact that you know from volume 1, page 28, that the invitation for expression of interest was issued almost 8 years ago. It will be 8 years ago in October. And you know that the matter was before council and criticized at that stage for delay over 6.5 years ago. And I mention that because of the unfortunate situation which arises that this piece of land, which, as you know on the record, is called the Old Market, that this piece of land has remained undeveloped and uncertainty has related to it for what is now an extensive period of time, and it has its own implications to which I'll come. But the heart of the matter we submit is this. Does our learned friend have an answer to the first point on Section 63 that, stand on one's head, Oshakati is not listed in Part 1 to Schedule 1? And we respectfully submit that there is no answer to that. And if there is no answer to that, then the minister's decision in terms of Section 63 falls to the ground. We submit it's no answer that the town council might have written to the minister saying, "Dear Minister, please take a decision in terms of Section 63. The council's view of the law, or my client's view of the law, of course, are not determinative and raise no kind of estoppel as to what the law is. And our learned friend would be driven into some discomfort for suggesting the contrary, because, for example, the council never thought, when it wrote to the minister, "Oh, Minister, would you otherwise take your decision in terms of 30TI?" It's all about Section 63 as a matter of vires, we submit. And either the minister had that power, or he didn't. And subject, my lords, to your needs, I would say no more on that topic and await to hear whether our learned friend squarely accepts that whether, as I say, one stands on one's head, you can't find Oshakati in Part 1 Schedule. Now, then the next question, rhetorically, for our learned friend is, what then about the private transaction point? Does he stand by the argument that because ultimately there was one horse left standing, as it were, after disqualification and after the ranking which took place, that this somehow was turned into a private transaction. And we submit that from the very first document, the request for interest, which I showed you, there was clearly a public procurement process which took place. And we've never understood it to be the law or the fact that because one car, inevitably it is a Toyota, is left on the last day of the Dakar rally, the Dakar rally is turned into some sort of private motoring exercise. If you have a public process and the process results in one entity standing, it doesn't retrospectively suddenly become private.
The advertisement kicking off the public process.
Yes.
26.
Yes.
There's no indication that I can see that the sale.
I can't hear my Lord.
No indication that the advertisement or the sale has been intended. There's no request for them to make proposals as to a price. So, I mean, there's no suggestion. If you read this on its own, you see that the municipality is going to develop the land and they want proposals for development. Absolutely no indication of the sale.
Well, I'm not quite sure where my Lord's point is leading, other than if my Lord is saying that this is...
Wasn't a public sale, wasn't a tender for sale.
No, my Lord. With respect, we submit that what is quite clear, and there's no point taken separately, as I think my Lord is raising on the deficiency that my Lord is of the advertisement, which is substantive. We're saying that it's quite clear if one then goes to page, for example, off the advertisement, into what the 15 entities reacted to, that there was to be the development of a commercial business complex. And it is quite clear from particularly 3.1, the council wasn't going to do this. The council was saying we need this development. So it could only be that way. If the council wasn't going to keep the land and develop itself, it had to be by sale to an entity which would develop.
That wasn't published. I mean, that's not put out there to the public that the land is for sale. The land is there for development.
My Lord, we would respectfully submit that is, first of all, not as we understand it, the minister's case.
No. Read the advertisement. You're a member of the public. You now read the newspaper.
Yes.
I understand. I mean, how?
Yes, but then, my Lord, point can only go to the deficiency. You get one of two things. One is that by reading the advertisement, one can characterize the nature of the sale as a private transaction, which is where I understood my Lord was endeavoring to go. Or one is trying to say that the advertisement was statutorily deficient. It is not the latter point. It then has to go to the first point to say that as a matter of legal characterization, it was private. And we submit that the advertisement does not change the legal nature. It could be that there's a legal challenge by somebody saying, you have advertised this as private, and in fact it is public, and we attack the validity then on the basis of the fact, the usual problem with advertisements, that I was dissuaded or blindsided from coming forward. But it can't change the main point, was for the statute, was this private or public? And the advertisement can't determine that. That's our submission.
Place on the record where price comparison is made and the test.
No. As regards the issue of price, as you know, what is done is at page 28 and onwards, the council says this: there is this piece of land. It wants it determined, and it says at line 19, it's more interested in the concept on page 28. My Lord, if my Lord's hold that by virtue of the non-prior specification of price, this is somehow changed into either a private transaction or on some unpleaded basis is rendered invalid, then I'm out of court. But on what is on page 28, the council is saying, we've got the old market. It needs to be developed. Not as a money-making transaction. From the beginning, they were clear and frank. They say They're interested in the development of the town. Frankly, price from the beginning was secondary, almost incidental. What the minister doesn't like, and one can understand it in the times in which we live, is that those who came second, or third, or fourth, or whatever, say afterwards, but there's something strange going on. It's not transparent, which is usually a prelude to a worse allegation which isn't made. It's not transparent, and that if you look at this, then you find that no price was fixed. And the council says, absolutely. We didn't fix a price. We're more interested in the concept design. Did it fix a price? Yes, it did fix a price. And the price it fixed in the end was to say, first of all, we've got the valuation roll, and that was the 950,000. And it says no, 950,000, and it bifurcates it. It says we'll take the separate decision on price. Then it multiplies that by, I think, 250% to 2.5 million, and then it goes up to 3,500,000. The crucial question then was the minister right? Because this is what he does do. He doesn't like that. And the reason why he rejected this was on this, the price aspect. And I can show you that by going to his decision at page 58, I think it is. And there he says it, 59, in volume 1. It's strongly implicit in his last paragraph to reevaluate the bids on clearly determined valuation measures. Why? The council has no prescription in the statute that it has got to sell at market price. It doesn't want to sell at market price. It's got undeveloped land, prone to flooding, which needs capital expenditure, engineering works, compacting, etc. It wants it developed. Naively, it hoped that it could be done in less than a decade. And what it says is that please give us proposals for development. If what the minister's point was somehow, and we're going to come to the difficulty with the minister's powers because they're undefined, but if what the minister said is, I can't approve this because on the face of it, there is no valuation, there is no determination, but he's wrong because there was. He might not like it, but the council, which took the local government decision, which is better we get this developed. We're not selling it below our own valuation. We start off with that. We go up by 250% to $2.5 million, and ultimately we push it up by another 40% to $3.5 million. But that's not what this is about. It's not an auction.
Part of the relief you seek is that there is an agreement in place because there's no commission list. Can you just tell me what you say is the price of the agreement that's in place?
3.5 million.
Not 2.5. That's
no.
the well, I'm not so sure. That's not how I understood the papers. But anyway, you say 3.5.
Yes. Yes. What the council wanted to do, to go back to the core thing, was not, as it were, to make money from it. Now, if the council, if the minister was saying effectively the council has not discharged its duties according to the non-criteria, and we're going to come to the significant CRAN problem which exists in this legislation, but not according to a particular criteria, but the minister says, I can't approve this because there's no valuation. What he wanted here, and it's spelt out in his affidavit, was a better price. Here in his letter, he says that. But what is his justification for his decision? And here, the minister is bound by his pleaded case, and may I just give you 3 references as to why he says that he was right. First of all, as regards the decision, may I just pick up on His Lordship, Mr. Acting Justice Frank's question. At 161, the first paragraph confirms the sale and the figure of 3.5 million. 161, my lord. Yeah, sorry, volume 2, page 161. It's rather clumsy, and you'll see the third bit was that it revoked the prior 2.5 decision, but 3.5 was fixed. And then, yes, but I'm not here in contract, my lord. Yeah, but what I'm here for is because what happens is my client agrees to pay 3.5. Well, we'll find a further reference. Since my lord is concerned with going into that aspect, we'll find it. But the suggestion is that there is no binding contract because my client did not agree to pay 3.5. I think we could assist, but let me not take up my lord's time now.
But that's not what was advertised.
I'm sorry, my lord?
That was not what was advertised as a sale. In fact, just tying up with my learned friend's question, it's page 122 of the record where the sale is advertised by the council, which is obliged to do. They say by private transaction, there's a sale of 2.5 million.
Yes. And then what was, my lord is entirely right. And then what happens
But
is...
it's also by private transaction. That's how the council understood it. There are two aspects. So I just also tie in with I know you speak about a bid in your heads repeatedly. I'm not accusing you of repetition, but that is what is the approach. And it seems to me strange to call it a bid in the context where price wasn't actually, there was no price.
Yes. Well, my lord, may I come back in dealing with Justice Frank's question to what our submission is that when you take it together, in the end, what one finds is a public process, unmistakably, so conducted as a matter of law, not determined by what is put in the newspaper. What is put in the newspaper may or may not pose problems for statutory compliance if the point is taken. The second thing is that the council is asking for a floor of municipal valuation. Council then decides it wants to get more. Justice Smuts draws attention to 122, which talks of the 2.5 million. At page 161, the ultimate process is the council says, right, it's at 3.5 million. And then the residual question is whether the papers do or do not show that my client agreed to pay 3.5 or otherwise agreed to pay 2.5 to make it an agreement of sale, or whether my client is deluded and is here and has gone through the High Court and is here on a wild goose chase because, in fact, the Oshakati Council never said, yes, please, Mouse, we want you, we'll take you. We said 2.5, but it's 3.5. It's really that in the end. Now,
I'm less concerned about the contractual side of that agreement. I'm more concerned about a process which seems to me on the face of it to be flawed.
yes.
Where from the beginning there's an advertisement. Maybe you can also just deal with that. The original advertisement, which can take you to that.
I think it's 27, my lord. 26 it starts.
No. I want to refer to the one in the newspaper.
Yeah.
There's actually a more legible version elsewhere.
I must apologize, my lord. I think in pages 29 and 30, I hadn't realized until I was rereading how badly reproduced they are. My apologies.
That's just the size of the print. But what was advertised was for people with a track record of high-rise constructions
Yes.
to put in a bid. And then people put in a bid.
Yes.
There's no limitation in the further description on page 28 and 29 about limitations of the size. People put in a high-rise bid for that, and they are simply disqualified because it's in conflict with the scheme. Now, the scheme is the town council scheme. They can amend that scheme. It's theirs, and obviously with ministerial approval and the like. What concerns me is the fairness of this entire process. And then you have a price that's advertised, which isn't the price which the minister's asked to approve. And Mr. Gordon, it seems to me, and that price is about 10% of the valuation of the property.
Oh, when you say valuation, you're talking about a market price determination by those who now know there is going to be a shopping mall after the compacting and the deflooding of the area. Yes, my lord, it's a fraction.
Well, and I understand your case is that wasn't the consideration, the primary consideration of the council, but taking all of those into account, isn't this process, before it even gets to the minister, somewhat flawed?
No, but the difficulty, my lord, is with respect to you're entirely right when you say before it even gets to the minister. We are not here on review from the council. There was no review of the council. The minister was asked to exercise his Section 63 power, which is to approve or disapprove of what the council had done. The minister disapproved, or sometimes the minister more tactfully tries to say it didn't approve, but didn't approve. Why? Because there was, in his determination, not market price, the effective issue. The question is whether the minister acted reviewably when he said to the town's council that he is so determining. What, with respect, my lord, we can't do is to conduct a sort of a Russian doll internal review of what the council did when that wasn't challenged and would need, obviously, to be challenged qua decision by the council. May I say frankly, my lord, there are aspects which are ropey. There's no doubt that it's a fluid and call it what you will process. But the legal remedy for that is then to hit the council by way of review, and any one of these disgruntled, jilted suitors should have stepped forward and said, you don't love me enough, I'm out, I'm reviewing you, I set you aside. This shouldn't go to the minister. It goes to the minister. Then the question for the court is, what is the minister's power in terms of Section 63? And that is when it becomes interesting, because the minister takes his decision on the basis that he gets a letter, as I said, dear minister, and he says, sure, you want me to use Section 63, I'll use Section 63. To which the answer is, not so fast, minister. You have to decide that you can use Section 63. And if the first point is that Oshakati is not listed, then you should have written a Dear John letter back to Oshakati Council saying, it's up to the jilted suitors to do what they like, but I can't deal with this under Section 63. And so that's why it's a vires point at the end, and it's a simple throat-cutting point that how is it that the minister picked up his pen at all in this matter? That is why that is the first and primary aspect of the case. The second point I've already debated, and let me not belabor, but earlier on, we say that it is clear by characterization that it is not a private transaction, that what appeared in the one advertisement does not determine its legal nature. What determines its legal nature is the entirety of the way it was conducted by a creature of statute in a public process, flawed or not flawed, we say is res inter alios acti now, but it was so conducted and resulted in one entity standing. And as I said earlier, that often happens. It doesn't mean that ex post facto the process changes. What are we left with? Deputy Chief Justice, we're left with the minister's defense, as it were. And on first principles in public law, the minister exercises of power, he says, under Section 63. He exercising that power, if challenged, must justify that he exercised it in terms of Section 63. Now, what does he say to show that he did exercise it in terms of Section 63? And may I just take you for your assistance to 3 or 4 short passages in his affidavit which seeks to do that. And I've already shown you his letter where he says that he's not going to approve this. He wants valuations. Then at page 208 in his affidavit, he spells this out in paragraph 24.4. I'm sorry, he's already done so once. At page 205, paragraph 21.2. Price is regarded as the most important criterion for the sale and letting of assets at local government level. There's no legal basis for that. He can't take that decision because on the law, as we say, a local government may decide we really, really need this area developed. We're not going to achieve, unless we spend a lot of money on it and get it up to 16, 20, 30 million rands worth of attractive commercial property. No, please.
I just want to ask you, there's no anywhere in the record that I can find some cost-benefit analysis to say, look, you're going to get so much in from this project, so we can reduce the value or the purchase price by so much, or nothing of that sort happened. So, I understand that price in this case, there will be a discount, or there's not a premium on price because you not sell vacant land, you don't want as much money as possible immediately, you've got some short-term, objectives. But surely, you can't just do a thumbs up. You must have some kind of process to say, look, this is sort of the valuation. We'll take the lower part of the valuation or a bit less because these are the projections. Not just poof.
Thumbs up is the word the minister uses, and we'll come to. May we make 2 immediate points and then seek to develop the answer to Justice Frank's important question. The first is one must be not sucked into the undertow of a review of the council when no review was launched, and was not before the court from which this appeal lies. The second point is that the council was clear and consistent about its stance, which was, and I've shown you the earlier references, but I need to take you to the council report where it's developed, where it says, this is the land, it's important in its location, we need it developed, and we are asking for the best concept we can for development. And they say money is secondary. Now, this is where it's interesting, and that's why I took you to what's at page 205. It's a slam dunk for the minister, and the review must fail if the minister is correct when he makes this in rem statement, price is regarded as the most important criterion for the sale and letting of assets at local government level. And we're saying that would be, it's a dangerous statement to make. It does not respect the constitutional divide sufficiently, which exists between government and local government, and the fact that local government must be able at times to say, we want to get rid of this land. We won't give it away. But what we will do, and this is what this case flirts with, always the suggestion of there's something going on. But we'll set as a lower limit. We will not sell it below our own valuation. Secondly, rises Justice Frank's question that there is thereafter a movement up from that. That movement is tracked only by an indication that it goes up by 250% and then by 40%. Our case would be that if it had not gone up from the valuation, it would not be impugnable as a sale. It was not a giving away of the land. It was for the considerations which are indicated, namely this is problematic. You've got to spend a lot of money on engineering works. It's prone to flooding. So the buyer stands to make a lot of money if they run a supermarket in so many years' time, etc., and have anchor shops and the like. It's not our business. We're not in the supermarket business. We'd like to see that because it's very good for the town. And they make a policy decision to do that. And then one has to get a grip on that. Is this court then, through the question posed by Justice Frank, saying, we don't think that's such a good policy decision? If we accept the minister is wrong when he says flatly, price is always the most important criterion, if the minister has no legal basis to assert that, and the local authority says, this is what we've done, open process, all come, put in your offers, what we're concerned is that we won't sell below our valuation, we would submit that this would be very problematical for both local government and for law in Namibia to say that in these circumstances the local government can't do that. And then on Justice Frank's question, what it hasn't done is to show how it gets to 2.5 or to 3.5. We would simply say it's more. And what it did clearly was to determine and assess, and no doubt there'd be a to and a fro, as to what was attainable in the circumstances.
But your attack on 1.2 is assuming the minister has the power under 63 to...
That's right.
That's...
Yes.
I know what your position is, but we must assume.
Yes, exactly. So really, Deputy Chief Justice, the first issue is what is the minister doing with Oshakati? It's off his
I
list.
just want to get back to that, assuming I accept what you have to say, that he didn't have the power to do so, but assuming he did, which means he would have been asked to approve. How could it not be a legitimate issue for a minister of state to be concerned about what price is?
Well, that's very important, Deputy Chief Justice, because the minister has no more power than he, through national government, is given through the Constitution and by legislation. And if the legislation says that it goes to the minister for Schedule 1, Part 1 municipalities, it means it doesn't go to the minister for non-Schedule 1, Part 1 municipalities. And he's acting in excess of jurisdiction. He should be saying...
No, I accept your point on excess of jurisdiction, but assuming that he had the power under 63 to do what he did, what I really want to establish is why would it be irrelevant for a minister to be concerned about price? For the considerations the considerations that my brother has mentioned.
Yes.
After all, this is public property. Ministers must answer these questions in Parliament, for example.
Yes, but political and legal, we would hope, are still distinct things. But the first aspect, Deputy Chief Justice, is then just to stack up my thinking, and I apologize if I was confusing matters. Number one, as you correctly identify, we say on the issue of is it in the list or is it not in the list, it's off the table. Secondly, we say on the issue of whether the Dakar rally becomes a private day's outing because one car is left, then, and it's not a private transaction, then on that basis too, it's off the table. As the Deputy Chief Justice with respect correctly notes, it's only at a third stage, if you reject our arguments on both 1 and 2, that you would say, right, it is now intra vires the minister. The minister can look at it. And then the question is whether the determination of price is how it comes into it. We say that one starts with the minister's approach. The minister is making a flagrant mistake of law here in his assertion that price is regarded as the most important criterion. It's not supported. And we wait to hear from our learned friend if there's any statutory or other support which says it is so. But also in answer to the Deputy Chief Justice, is if you would go then over the page to 206, paragraph 23.1, he correctly there, and somewhat inconsistently with what he's just said, identifies the focus of the council. He doesn't say that focus is wrong. And that's our point. The focus could do this and say it's not going to be a money spinner, but we try to work out how we get the old market quickest or best developed. And then comes 21.4 on paragraph 208, which is a blunt reassertion as the most important criterion. A second reiteration of his mistake of law. And it's followed up by this, my lord, which goes to your questions about, he's answerable in Parliament and the like. The price must reflect a true, accurate, and fair value of the property. Where does he get that from? I know it sounds axiomatic, but what if a council decides that for socio-economic reasons, there's an underdeveloped part of a particular municipality, it's bad land effectively, you've got to spend a lot of money to get it right. We should have it developed because it's otherwise well located. And what it does is to say, we work off, and public entities do this, off the valuation roll. They're not going for market price. He then imposes from the beginning, and he's told us that, and this is his mistake of law. There's one most important criterion. And then he goes on to say in paragraph 26.4, second mistake of law, last sentence, this decision was done without the use of tender procedures, but rather by way of private transaction. He can't say that. It's flat wrong. And then it comes at page 215 to the phrasing which Justice Frank reflected or mirrored in his question to me, that the council opted to suck a price from its thumb that was offered to the applicant. But why? It worked off a minimum. It got, as happens with local government, it got more. Did it have a cost-benefit analysis? No, Justice Frank. No, it didn't. Its decision wasn't reviewed. What we simply have then is a minister who says, I take a decision under my powers, under Section 63, and with respect, Deputy Chief Justice, the wish can't be father to the thought. It can't be that the minister's got to answer questions in Parliament, ergo he has the power. You've got to look what gives him the power. And we say only the Section 63. And what does Section 63 do? It means that he's got to look on a basis which at its lowest means he should not impose as a mistake of law. Highest price determines this. That is where effectively he's gone wrong.
I get your point on that, but to assist me, what sort of considerations could he have given for refusing? Putting price aside, what could he have said? Assuming he had the power.
And if I can just amplify that. I also have heard your criticism of the price. I hear your criticism of his formulation of high price, but yes. I'm actually also concerned about the constitutional principle of accountability to be dealing with. And if one has a look at the constitutional principle of accountability, which must be obviously at the root of any disposal of public assets. If you don't get the best price for it, there must be clearly an important justification that's given. And so I'm concerned about this transaction, and I know you emphasize that, of course, the council's decision is not in review, and of course it's not. That's not what's before us. But what you do stress is that what the minister was doing is the culmination of a process, is it not? Now, just going back to what the Deputy Chief Justice has put to you and what I've amplified, my concern simply does still remain is that, and you talk about a public process, but if that whole process which preceded the minister's decision is flawed, even if it's not reviewed, must the court just turn a blind eye to that?
Well, if
And that-
really
and
interesting.
that's a separate question to what the Chief Justice put to you, but for me, I just want to put it in to tie up with what his question is to you and with what I've said about accountability and having a look at the entire process in the accountability questions that essentially that have come from both the Deputy Chief Justice and my other colleague.
Yes. So the setting is, again, and this is the quandary. I take Justice Frank's point. The court is asked to consider whether the minister's decision was rightly upheld by the lower court when there was a review against that decision. And in taking that decision, the court gets concerned that at a lower level, at the level of the council decision and process, there are aspects to it which it regards as not satisfactory. I still raise the point which the Deputy Chief Justice accentuated again for this court in the Hollard reinsurance case regarding the application of eau de corral in the court. And that is, if you have, in this court, if you have a decision which stands, as the council decision stands, unreviewed, and it goes to another decision maker who is asked to approve or disapprove, and let's accept an extreme case, disapproves on a completely frivolous basis, completely capricious basis. The court then says, our court as a court of review has a decision on a rule of law and legality basis to say, can that decision of the minister stand? Or was it off the wall? Is it an answer? Is it open to the court, the High Court, and then on appeal from the High Court to this court to say, we have to say we didn't like that original process. And our submission to my lords, and I make it again, is that with great respect, this court takes the case as it comes. And if the other property developers thought it more assiduous to lobby the minister, as they clearly did on these papers, rather than to exercise their rights and their proper remedy, which was to review the council, if they saw irregularities in the council, then this court, with great respect, can't, as it were, penalize my client by saying, there's a case you never had to meet. It was a review of the council decision. There were no papers alleging irregularities and things we don't like about this advertisement and this lacuna as regards cost-benefit analysis. Aspects never run. But what we're going to do, even if we're driven to the conclusion, first of all, against me, assume that the minister somehow puts Oshakati on the list, assume that the minister somehow says this became a private transaction. Then at the level of the decision of the minister opens his mouth to put both feet into it by saying there's one criterion, and that is price. And if the minister is misdirecting himself fundamentally in that regard, and not doing what I'm about to show you in answer to Justice Frank's question, which is the wider decision the council was taking, then the minister, the minister's decision can't stand on the review merits. So there are three hoops through which the minister had to go in the High Court. And the minister was led through the first hoop quite wrongly on this, with great respect, jury basis, that if a letter gets written by Oshakati saying, please, minister, do this, the minister says, right, you asked me under Section 63, I'll do it. It's a different thing for him to say no, and by the way, I write back saying I have concerns. That is what a minister could do. Or a minister could in Parliament respond appropriately, saying, well, Oshakati took this decision, it's its decision, and I wrote back to it and said, nobody's reviewed you, but I have these other concerns. But the legality point is, what jurisdiction did the minister have to do this? And if he had jurisdiction, getting over the first two hurdles of the list and of private transaction, then on what basis was he just going nap on the point that he did? But may I now answer Justice Smuts' question, and that is, which, because I would like to address it on regarding what the council did. The best record is from 144 on. where it's set out in the report. Sorry, that's in volume 2. There is a proper indication of the process of inviting expressions of interest. It sets out, top of 146, what was required. It sets out the technical evaluation process on 146 running through. It lists them, and then at 148, it says the company scored so-and-so. They proposed 2 floors in compliance with the town planning scheme of Oshakati. May I just say briefly, my lords, that if anybody is responding to such an invitation and doesn't read the town planning scheme of Oshakati and thinks they can put up a Singapore skyscraper, then it might be thought that they have their own difficulties. If they don't accept that and they think there's a deficiency, they should review the Town Council of Oshakati, which is otherwise entitled to say, well, we're Oshakati, we've got a town planning scheme, didn't you read it? And then we come to the footer 148. The objections only complain about the price, and secondly, the reasons or criteria. Now that's important, because with a great respect, it goes back to my point, there is no review of the council decision before it. So even at this level within the council, you can see what they're focusing on. And then comes the answer on how we got to the money. And that is at 149 in paragraph 361. The 4 evaluators have been requested. The average price of the facility by evaluators is $18 million. While the council valuation roll shows that the property value is only $903,000, in view of the above, the council took a decision as the latter amount as a yardstick to the price of the land. And then comes the fact that they increased it. Cost-benefit analysis? Of course not. They didn't do that. They looked at it and said, in effect, we could sell at $900,000. We've been given these. We've considered them. My lords, either there was a good review of the council to say the council was irregular, could never have gone for 2.5 and then 3.5 million rand. First of all, because of the 18. Secondly, because the minister's obsession that you can only sell for the best price happens to be right in law, which nobody, apart from the minister, has asserted. And thirdly, on Justice Frank's point, these are jumps. And there's something irregular in the jumps. But we respectfully submit that this results in 151, where after council deliberation, the council resolves as follows. On 3.5, first paragraph, since the owner needs to compact the ground level, council saying, Old Market, important location. It's a terrible site. You've got to spend a lot on it. And what we've done is we've seen that it's got a higher value. We've thought about it. And we get to 3.5. And that's where it stays. We respectfully submit. So
I want to nudge us on a little to move. I know we.
I'm sorry, I didn't hear that.
I just want to move us on a little.
Yes.
I know we engaged you a lot. But I'm
you.
worried about us taking a lot of your time. It's about 11.
No,
I'm sure you want to move to 63.
I am, and you put it very tactfully, Deputy Chief Justice. You have my argument then on section 63, the 3 points to it. One is, if it's not on the list, it's not on the list. Secondly, what happened didn't turn it into a private transaction. Thirdly, the minister's approach to it was irregular in that he makes the 2 mistakes of law to which we have pointed. He occludes his own jurisdiction. He doesn't consider, he doesn't refer in his affidavit or in his letter to this town council report saying, but apart from price, I don't agree with you. I just don't, he doesn't engage with it. And so he treats it as if he's got some kind of naked veto. And it goes back to Justice Smuts's point regarding accountability and also division of powers under the Constitution. The minister is not King Louis XVI. He really, with respect, would have to set out other criteria. And if what he sets out is wrong, then it's wrong. May I then deal with the second point in the case and the concluding point? And that is this interesting point of section 30 TI. Now, first of all, we draw attention to the fact that the minister pleads no reliance on section 30 TI in taking his decision. And my lords are well acquainted with the decision in Yanuko versus Apollo Club, in the Justice Holmes decision in the Appellate Division in South Africa when it was still the highest court for Namibia. 1974-1, 614 at 632G, followed in Namibia, applied in Namibia by Justice Smuts for this court in Claude Bosch Architects versus Awis Business Enterprises, 2018-1, NR 155 SC at para 16, and also applied in Denker versus Ahmed Rhino Sanctuary, 2017-14 in this court, 2017 volume 4, NR 1173, and right at the beginning in the famous case in the then Southwest Africa of Wasmouth versus Jacobs, which members of the court will remember from their lost youth. 1987-3, 629 at 634I. So what is the point we make? The point we make is that in his answering affidavit, what power does the minister invoke? He invokes specifically only one, section 63. But in a phrase much loved by advocates and others who draft papers, he does try to fudge it a little. And he does that in his affidavit in two places, at page 213, paragraph 32.9. We're having, in the first paragraph, 212, paragraph 32.8, pleaded quite correctly a reliance on 63.2b. In 32.9, he says, in any event, well, that's no good. In terms of what? He just says, in any event, my permission is required. And then he actually cuts and pastes the same wording at 219, paragraph 47.8. In any event. So first of all, on the authority of this and other courts, you can't do that with a statutory provision. If you want to call in aid a provision in terms of which you acted, you must either plead it by specific reference or at least by recognizable paraphrase. And he did neither. But secondly, on section 32I, there is this problem. Because it hasn't been pleaded and hasn't been ventilated, the difficulty remains that one is left with a situation to which I alluded earlier, and that is the CRAN judgment of this court, Communications Regulatory Authority of Namibia, by His Lordship presiding together with Justice Smuts versus Telecom Namibia, 2018, volume 3, 664, para 18. And following Medical Association of Namibia, 2017-2, 544 at para 85. And what that held, my lords will remember, that an empowering provision must not simply grant wide and unconstrained discretion without accompanying guidelines on the proper exercise of the power. Let's just look at section 30 TI. May I say where I'm going with this? I'm saying that if this had been raised, pleaded, and ventilated in court, it would have invited a constitutional challenge to a reliance on 30 TI on the basis of CRAN. You can't just, as in the old way, give functionaries some power and leave them at sea how to deliver it. That the Darwood principle is applied in CRAN. If you look at the provisions of 30 TI and our heads of argument, we replicate it on page 28 for convenience. in paragraph 60, then you will see there's absolutely nothing which is given by way of guidance. It almost replicates the Cran language. Now, my lords, in our heads of argument, we have additionally drawn attention to the fact that there is this problem in the construction of 32 Ti if it did come up for decision. May I say that last night our learned friend very helpfully managed where both he and we had failed before, and that is not with help of the website or of a Judistat database, but by kind courtesy of Google, and Googling his client's name, he found a Supreme Court decision, a previous judgment of this court, which is a judgment of Justice Maritz, acting Justice of Appeal as he became Stradom, and Justice Mayinga. And he kindly made it available to us. That judgment is in terms which goes against our construction. And I just want very briefly to deal with it, to make available, if I may, if my learned friend has kindly made copies. Thank you. The copies are sanitized, my lord, at least by my learned friend. They're not sanitized of error, but they are sanitized. My lords, may I say that it's a case known generally, I think, as Northgate Properties. And may I just take you to the heart of it, because you will obviously otherwise read it as you will. There were two issues in the case, and you pick those up in paragraph 43 on page 22. And that was that issue which I've learned is much beloved still in Namibia in the 21st century, namely Lokostandi. And that's in paragraph 43. It has nothing to do with us. And then comes that which does deal with, is important to us, and it's page 24, paragraph 47. And that is the validity of the sales contract. And there the court says, in the second sentence, simply this: I am satisfied that any selling of a movable property is subject to prior approval in terms of 32I. And then the section is quoted. No further reasoning, no recordal of argument in this regard. And it is a statement acting by the former Chief Justice, by Justice Stradom, that he's so satisfied. When I say no further reasoning, he returns in paragraph 49 to give this important reason, which we respectfully think in the first sentence is per aurorem. And that is, I am further satisfied that the words or to so let, sell, etc. can only be a reference to the manner in which it can be let or sold, namely with the prior approval of the minister. Otherwise, the word so would have no meaning and would be redundant. We pause to say, as you know, on our interpretation, we say that so could equally refer to so sold, i.e. for the purposes of the act, and that in those circumstances, it's inconclusive as to what it entails. You look at the purpose of the statute, and the minister would not be concerned about anything other than the local authority getting into debt. Now, that's our construction. So what we say, and I'm not going to elaborate further because it's fully written up, we say that with respect, it was per aurorem, there's no recordal of any argument, particular argument in this regard, and with great respect to their lordships, if it arose for determination, we would ask you not to follow it. But, my lord, it's not our primary point. Our primary point is that section 30 Ti is, or T1, was not invoked by the minister. And interestingly, when the town council sent it to the minister, they said, Minister, please, would you do this in terms of section 63, which they were wrong on, as we say. They didn't say in terms of 30 Ti. The minister, what started, though, was my predecessors in the case thought it astute to add in the notice of motion and elsewhere that you can't do this under section 63 and or 30 Ti. And then in the answering affidavit, what happens? The minister now should say, well, actually, yes, I also did it under 30 Ti or T1. He doesn't. So he hasn't pleaded it. He hasn't relied on it. it again falls off the table. And so the question of whether or not this other decision should be followed does not arise. If it had been put on the table, we would have attacked it on an absolute cran basis. You cannot not give guidelines for the determination of powers. That hasn't been ventilated. It can't be done on the back hoof, off the pleadings, never invoked on appeal. And so the simple point is the minister didn't rely on it. It's not in the case. And that chip must lie where it falls. If it means that we succeed on the simple basis that the review should have been upheld, Oshakati isn't on the list. It's not a private transaction. Thirdly, the minister's decision is that on its merits reviewable, then that should be set aside. And the relief we ask should be, at worst, narrowed to that, should be set aside. And what should then happen is that the chips lie where they fall, in the sense that if the minister then seeks to pick up cudgels on 30 TI or anybody else, they must. But nothing else is justiciable, we respectfully submit before this court. It's only what the minister did. And what he only did was Section 63. I'm sorry I've taken so long.
No, not at all, not at all.
My Lord.
I just want to be sure about... Yes, please, yes, please.
Mr. Gordon, sorry, page 36 of the record,
Yes, my Lord.
volume 1, I just want there, the lawyer for your client quotes the two sections. I just want to confirm with you, would that be the correct quotation of the act as it was then?
Yes, my Lord. That is the act as it was. Yeah, and the judgment as underlined also so quotes it, my Lord. But it only in those respects, my Lord.
And then I just want to ask something which is probably taken from a different context. When the council made a resolution to sell, our first resolution to sell, it said, look, it will be conditional. Firstly, we won't be able to resell it undeveloped. We've got a right of preemption. Secondly, there is some attempt to say foreigners, not sell it to foreigners.
Yes.
And thirdly, it's made conditional on the approval of the minister.
Yes.
It's got nothing to do, and I'm not talking statutory,
Yes.
I'm now talking contract.
Yes.
Offer and acceptance.
Yes.
Your client accepted that position. I mean, why isn't he bound by that, irrespective of what the powers the act give to the minister?
Meaning, my Lord really, and there's been a flirtation with this on the other side, and my Lord steps up to the plate to raise it again, and that is a sort of a waiver by my client, because my client, my Lord has said, might be bound by a letter which says, this is to go to the minister, and we're bound by what the minister does. Our answer is given in the heads in relation to the fact, accentuated in a public law setting, I may say, but accentuated, the point was there an unequivocal abandonment of rights by the particular party concerned. And if the party concerned at the time, as the affidavits show, and the correspondence reflects when Mr. Namanji states this, that he's now taken advice on this issue, and the minister doesn't come into this, then it was simply wrong. And it is pronounced, yes, my Lord, it looks surprised. If it's legally... No.
Common assumption of the law flows, not pronounced.
If my Lord is assuming, positing, again we get back to the law of contract, it seems, but being bound by a common assumption as to the effect of a statutory provision, and advice is then taken that the statutory provision has nothing to do with the case. My Lord, we would respectfully submit it to be a startling position for this court to adopt, to say that a party is bound in circumstances where it's not shown according to the normal criteria that it's got full knowledge, etc., of the rights, and it is agreed that there should be a decision by the minister. There was clearly a mutual, implicit assumption that the minister had more to do in the case than the Queen of England. If they had said, subject to the Queen of England, and it was clear that it is a legal assumption, then, my lord, it's legally ineffective.
I know those kind of assumptions doesn't void an agreement. I mean, unless it's a condition of the agreement.
Now, my lord, you see, I would respectfully submit that my lord takes it each time into an area of severed white-collar contract. What we're saying is the only reason why this is happening is because there is a public procurement process in terms of which the town council is saying, we think the minister needs to approve, and my client goes along with that, then on its legal advice and says, yes, well then the minister must approve. And if that common legal assumption in the regulatory setting is simply not right, then, my lord, we would submit that the party isn't bound by it. If you hold, however, otherwise, then...
You're saying that in the public law context, you can't apply the law of contract principles.
Yes. Thank you. My lord puts it as always more crisply than me.
I understand that argument. You, with reference to the public law setting of this scheme, which must be taken into account in its entirety, and that your client hasn't been brought to defense or deal with issues which are not. But
May I interrupt, my lord? I'm awfully sorry, but just to assist in that regard, before my lord moves on, by giving the reference which I meant in passing to Mr. Namanji's letter at page, usefully that page isn't paginate, page 35, where he states, look, let's clear it up. This is not the law. I apologize, my lord, you were going to...
You say that and then the minister doesn't in his affidavit identify the section. And, this court has dealt with Apollo and those cases. And you say that your client would have wanted to deal with a Crown challenge on that. But that isn't foreshadowed in your argument, though, after this provision was raised. Section 30 was raised. Wasn't it raised in the court below?
No. No, my lord. The Crown attack was not done at all. What happened?
No, not the Crown attack.
Yes.
Section 30, wasn't that raised in the court below?
Yes. But we've dealt with it in our argument, in our heads of argument. We dealt with 30. We said 63 is no good, and we have our argument on 30, which then draws us into combat with the other decision. And what happened then last night was, through our learned friend burning some lamp oil, this further decision is found, and we then thought further along these lines, that if this argument had been run on 30 TI, we would have met it with a full-on Cran attack. And this is one of the problems when you have a Yanako non-pleading of a defense. We just didn't. Thank you for my lords for their patience.
Thank you so much, Counsel. Yeah, we'll take a short break. Be back, say, 11:30? Is that good enough? We'll rise now until 11:30. Yes, before we move on to Mr. Patela, the court wishes to raise a few issues with the
Yes.
Yes.
Thank you. Sorry, Mr. Gondar, if you can just have a look at that section, wherever you've got it, that section, page 36 is probably the easiest way of reference to section 30T1 and 63.1,
Yes,
section 63.
Yes, my lord.
If you look at section 63, it is subject to the provisions of part 30. 30T. And then section 63 is part of part 30. Is that, do we can accept that? Okay,
I'm struggling to hear, my lord.
I'm sorry.
Yes.
Section 30T, which is at the top of the page, it's subject to the provisions of part 13.
Yes.
And then section 63, which is quoted below, is part of part 13.
Yes.
Is contained in part 13.
Yes.
So,
Oh, yes. In the statute, there is
yes.
absolutely that link.
Yes.
In what the minister invoked, there was no claim to 30 TI.
No, I just want to take you to 63 itself.
Yes.
If we can just look at, and forget it, okay, we'll get to the schedule, because I think the schedule is maybe irrelevant, the way I look at it. If you look at section 63, if you look at subsection 1 and you get to the end of the first paragraph,
Yes.
and if let's do A first. Approval of the minister shall not be required
Yes.
in relation to the letting of immovable property for a period of not exceeding 1 year.
Yes.
Doesn't that by implication mean if it exceeds 1 year, it shall be required, on terms of the ex contrarius maxim? So then we go to B, which has got the same introduction. The approval of the minister shall not be required for the disposal by a municipal council or municipality referred in part 1 of the schedule.
Yes.
By implication, it means it shall be required in respect of any other municipality, or town council, or village council. On the same principle. What it then does, if as I read it, it then says, if you are Schedule 1, municipality, Part 1, Schedule 1, you don't need our approval, but you have to follow a certain procedure. That is, if it's objected, there's an advertisement, etc. The stuff we were discussing.
What your lordship puts as an implication, which I would like to discuss, and if I may.
Yes, maybe you can just think about it and in
Thank
reply. And I think because the further point I'm trying to make is because 30T is subject to 63, they by necessity must be read together. But you just think about that.
Yes, I've already said that if you have an instance where there's a statutory power, what my lord is putting to me is that if a person says, in terms of 63, I do X,
Yes.
and there's no claim to anything beyond 63, my lord is saying, well, pregnant within 63 is a raft of other provisions.
Yes.
Well, you've had my submissions on that, my lord.
Okay. May I then just ask you that, assuming for the moment that we've got, what's the decision? The Tullahoon Northgate Properties decision. That section 30T, as it stands there, means ministerial approval is required.
Yes.
And that's the position of this court. Assuming that you're correct, and the minister didn't act in terms of section 32, mustn't we then refer it back to him to act in terms of section 32, because the act says you can't sell unless he's given approval in terms of section 31T?
Not if we don't ask for any relief relating to 30 TI.
No, but isn't that a question of legality that we must take cognizance of as a court? To say, but section 30 TI, which requires his permission, was never followed. So we must set the whole thing aside, and the minister must exercise his discretion in terms of section 32.
I think that would be right. Yes, my lord.
Thank you.
Thank you very much, Mr. Undlet, for your submission.
Oh, sorry. Thank you, my lord.
Thank you so much. Yes, Mr. Patel.
From the
flagged by Justice Frank is exactly where I was going to start.
Okay. Yes.
There cannot be any reading of Section 63 without Section 30. So,
I'm sorry, you'll have to repeat. I was busy.
yes, no problem, my lord. I was saying that there cannot be any reading in our submission of Section 63, which excludes Section 30. The powers of the minister in view of the transfer of land out of the local authorities starts from Section 30T. This section was also quite topical before the Kotakuo. That's why maybe it would explain the Kotakuo quoting the entire section in its judgment on page 310 of the record, because that is the starting point of understanding all the processes that follow thereafter. So our contention, Your Lordships, is that whether one has regard solely and exclusively to Section 30 and or Section 63, all the roads lead to the minister for approval. The only exception that you'll find in Section 63, and we need to take a bit time because this aspect is quite important in our view in order to clarify perhaps some of the understanding that we have in approach to Section 63. It would appear that there are different levels of local authorities. There will be village councils, there will be town councils, and there will be municipalities. When one has regards to municipalities, there will normally be older municipalities that have been functional over quite some time, that would normally have quite a lot of policies, and their systems are quite entrenched. Sometimes the new town councils, one would find that they are still struggling even to understand what their tasks are. I'll deal with that, but there is, and I'm trying to understand what the legislature intended by saying certain local authorities are accepted from this requirement of approval of the minister. So the three municipalities that we have in Namibia, which is Windhoek, Swakopmund, and Walvis Bay, were exempted, but only on very, very narrow basis. If they dispose of the property, they must engage with objections. If there are no objections, they can go ahead and sell without the intervention of the minister. But if there are objections to a particular sale, then the entire process has to be brought to the minister for the minister's consideration. So Section 63, when I look at it, it also imports, at the very beginning of that section, it imports the importance, it reminds the reader of the importance of Section 30T. It says, that is the starting point. So our submission is that the true and proper consideration and understanding of Section 63 cannot exclude Section 30. So the analogy that it was not pleaded, it's not helpful in this instance because it's brought and imported directly by the provision itself, Section 63, at the introductory part of that section. So then the section itself, when one has a look at it, there's often been confusion in regard to how that section operates, and we need to be careful because that act has since been amended. This was the act as it was applicable when the subject matter of the decision was being taken. 2018, I believe it was 2 or so months after the decision was taken, a new amended provision came into place, which has since changed the landscape. So when one does research, it's also quite helpful to look at the old provision as it was at that particular time. So, Your Lordships, we have already provided the authority, and I apologize that I did not come across this authority timeously in order to have brought it off the understanding of Section 30T. But I made the effort to email it to the instructing council of my learned friends so that it's before the court. This is the Northern Property Northgate Properties matter that he brought to you earlier. So if we are clear that whatever the circumstances, the approval of the minister is a prerequisite for alienation of immovable property, then perhaps we can come to the smaller issues of the processes that were engaged either by the minister or the town council in this instance. But the approval of the minister, there is no question about it, it's a requirement. In fact, in one of the judgments that were dealing with that particular provision, although I know Justice Damaseb, you are often cautioning us that we must be careful not to cite judgments of the High Court before the Apex Court. That's why I tried very hard to try to come to this one of the Supreme Court. But there was a judgment of Justice that was Justice Van Niekerk, who also spoke about the issue of the requirement of ministerial regulation, particularly in the context of municipalities and these town councils and local authorities that do not even have proper processes, as we have seen in this instance. That it would appear that this town council of Oshakati really does not have set processes for alienation of town lands. And that's why when one looks at how this transaction went into, from the beginning, the advert itself, when one looks at it, it raises a lot of questions. Is it a donation? Is it a sale? The price is reached. Nothing seems to inform that price. When we look at the papers, if I can take you now through the papers, because then I'll come and deal with Section 63 in the context of the papers. If we look at the papers that were the record of the court, that was before the court approval, about what happened in this instance. If you go to page 122, that will be volume 2, your lordships.
122.
Yes. Volume 2, page 122. It was annexure PM4 to the answering affidavit of the minister. For the first time, the nature of the transaction, at least insofar as the public is concerned, is announced by the town council, that it is a sale. So it is no longer a development, it's no longer just, they say this is a sale of this immovable property, and there is a price that is put there. I believe that the minister exercising the powers, being in charge of the properties, these are public properties. One of the key things that obviously one would look at is the process, of course. But in the end is that the public property is being alienated. At what cost? At what price? It is a factor that cannot be minimized in its importance. In fact, the minister will be derelict of his work if he does not consider the price. How much is this property being alienated for? And what informs that property price? 2.5 million. Let's assume that this is a good price. But then from there, the minister looks at the town council itself that took a decision to say, well, as the council, we need to be informed, but people that know how much the value of the land is. They took a decision. If you go to page 132, from there, these are the valuation reports of the land itself, which had been requested by the very same municipality. Not municipality, the town council. The town council itself said, we want to be advised as to how much it is. They took a resolution. The first price that is recommended there on page 134, and I'm being very conservative about the price. The price comes out as 16 million for the land in question. 16,177 square meters for 16 million, 115,000. The next valuation, and it was not just one valuation report, there were several of them. The next one, your lordships, will appear on page 136 of that bundle. It puts this price at 24 million. And then it goes on. There are other valuations. I believe I submit that the highest one that I came across in the record, piece the property at around 30-something million. There is no explanation to council. That explains their price. We know that they reach a conclusion that the discount, this huge discount that is silent on how they arrived at it, is based on the cost of development. Let's assume and give them the benefit of doubt and say, okay, they are correct. But how do they know? Because in the record, we don't have any cost that has been provided, a technical report, either from a man on the street or from a quantity surveyor to say, to compact this land, to do all this, and so on, this will take this much amount. So that it's very clear then from the cost how the deduction goes on from this valuation to about 2.5 million. At some stage, then they go further, they increase the price by 1 million. The same council, there must have been something that went on. They increased the price by 1 million to 3.5 million.
So which price is the appellant? Which price is the appellant tendering? Which, in terms of the agreement that he asked the declarator for? Is it agreement for 3.5 or agreement for 2.5?
Lord, it would appear to me, if I look at the papers, it would appear that it's 2.5 million.
Okay, move on.
Because there is no indication as well how this increment of 1 million, assuming that the 2.5 million was built on rational basis, setting out the consideration of the development of the land. How does that variation now of 1 million come to the picture? Did they make the mistake in their own internal variation? And a minister still sitting in Windhoek has an obligation and in fact a responsibility to ask this question, because this is what comes from the municipality's own documents. He doesn't see how the price was arrived at an evaluation. Now, the bids are also, there is a process to evaluate the bids. The minister says, okay, if you are town council, regulation, the town scheme is that 2 floors is the maximum that can be constructed. You have given one entity 100 marks, 100%. And yet they had proposed 15 floors. Why was this entity not disqualified? Because, of course, the property, the proposal that they put forward, if it makes sense, it violates your own town scheme. This is in respect of the other 3 as well that came to us. The minister as well is given information that this is over and above the revising of the price to 3.5 at 161. His Lordship can look at it, the revising of the price at 161 to 3.5 million. Of course, how the decision also comes into place, if their Lordships, I'm sure that you have heard, I don't want to traverse all this but they are there in the record. There are different layers of governance within the municipality. One of them is the technical evaluation, one of them is what they call the land committee, and one of them is the management committee, which is a statutory committee, prior to issues being recommended to the council. The processes that went in there, in fact, it appears when one looks at the record that the management committee was completely eliminated from the process. So the 2 other components, one of these technical evaluations was saying that the parking spaces proposed by the appellant, they don't seem to meet the very requirement that there has to be 1 parking space maybe for every 50 square meters, etc. This is the information that comes to the minister. And therefore, the minister is entitled to look at this entire process and say, wait a minute, something does not quite add up here. Now, what is the decision of the minister? The decision of the minister is not that, no, I don't like the appellant. The minister says, you have requested me to exercise my powers in terms of Section 63 to provide the approval. He says approval has not been granted. But that is not the end of the road. The minister does not say that is the end of the road. If the minister had said that, perhaps there could be merit to the criticism that his decision itself is reviewable on some fair grounds or lack of rationale, etc. The minister says, I have not granted you the approval, but go back and evaluate the tenders. based on clear guidelines, so that I know at this stage how you arrived at the
So
decision.
if that decision of the minister is allowed to stand, whose standards are being re-evaluated?
Disqualify all those that did not qualify.
Sorry?
The minister's view, the way I understand it, Deputy Chief Justice, is that he says, disqualify those that were not supposed to be assessed any further because their proposals did not meet the requirements. Go and reevaluate.
But who remains? Who remains after 10 years?
That could very well be a consideration, but it's not for this court. There is no contention that the other ones have lost interest after 10 years.
No, it's not a question of others losing interest. The question is, on the papers as they stand now, who are going to be these others? Who are they? Whose standards are being evaluated, re-evaluated?
Those
Do we know?
Yes, including the appellant.
No, but the others. The persons who were ranked first and second who exceeded the height levels of the town council, who proposed 15 and 11-story buildings, are they going to be re-evaluated?
The first and the second, Justice Frank.
The people who were ranked initially in terms of that report by the technical committee of the land, whatever, Lands and Housing Committee. The one that came first proposed a 15-story building. The one that was ranked second proposed an 11-story building, which on the papers is common cause, and that's outside the limits of the town planning scheme. Are they going to be re-evaluated?
The way I understand the facts is that it's clear that they propose 15 or 11 floors that are clearly outside the regulatory framework. So those ones will be disqualified, of course.
Well, but how many qualified in terms of the land town planning scheme? Only 3, isn't it?
Only 3 of them.
Yes, and one is already withdrawn because I don't know why. So in fact, it will be a choice between B&H and the appellant.
That may very well be for, but what the minister wants is that the evaluation has to be done on clearly defined criteria. And we can't preempt that process by saying, well, there is no need to evaluate them further. I mean, this is the whole work of the town council is based on the rule of law. They have advertised and they have set down the criteria. Let the criteria be followed.
And how will the price then be determined? Again, by private sale?
Well, it will be determined by the date of the valuation of the land, as at the time when the transaction has to go through.
Yeah, you will see, Council, the questions we ask, we are concerned about uncertainty
Yes.
that our decision will create. If the minister's decision is allowed to stand in the form that it reads at the moment,
Yes.
do you see a problem of that? If you don't, let us know, but you can see the problems we are experiencing with the decision as it stands now.
Your Lordships, this is the difficulty that I have. There has not been an additional submit because parties are also free to submit additional facts to the court of the status quo so that those are taken into consideration as additional facts of the status quo as it exists at the moment. The point that I'm trying to make, Deputy Chief Justice, is that in a review, apparently, we are tied down to the facts as they existed when the issue was brought before the court of law. And if this court...
You're confined to the facts of this case. Our questions relate to what do we do on the facts of this case?
Yes. I submit that the only viable option that I see that is based on the facts before this honorable court is for the matter to be remitted back to, as the minister had decided, to remit it back to the town council for the proper valuation that is in line with the town scheme, that is in line with the evaluation processes, and let the winner come forward.
What does it mean, proper valuation? What does it mean? Re-evaluation of what?
That was quite the decision there, Your Lordships. I do concede that there was a little bit of lack of clarity in terms of what exactly had to be done. But that was not, if I look at what the minister decided, if we can go to the decision of the minister, it's on page 59, thank you. The minister says,
given an opportunity to make representations, could this not have been some of the concerns that they could have raised? The minister, this is what you want to say. What does re-evaluation mean? It doesn't mean anything. It creates uncertainty. Therefore, give a, the difficulty is to allow the minister's decision to stand in the form that it stands now.
That I understand, Deputy Chief Justice. But also, I think it will be compounded by the difficulty of the relief that is sought by the appellant as well. But let's, for a moment, let me move away from that. Let me focus on the challenge that the court is facing. I believe if the minister says the council is directed to reevaluate the bids on clearly determined valuation measures, council in its own policy has these determined valuation measures. For example, that it has used to assess, all these people that bid, but for some reason decided to omit those requirements. I've just made one example of, for example, the issue of the number of floors of the construction or the design, where one company came with a design that is clearly outside what the council itself required. But for some reason, they were still evaluated further instead of being disqualified. And number two, the evaluation criteria is also available because it was set out as well in the papers. There was no, and following the governance structures or the governance procedures. This relates to the decision-making levels. That there are all these committees that came to make inputs, technical inputs. There is also the management committee, which is required by the statute, that was never included in the approval levels of these decisions. That's my understanding and interpretation.
What if the council says, look, that's not how we understand that. It cannot involve that committee, it cannot involve the other committee.
Yes, but the difficulty is that, unfortunately, I can only deal with what is written here because council, for some reason, decided not to participate in these proceedings. And therefore, one does not clearly understand what would have been their view. But looking at the decision of the minister, one looks at it.
Sorry, if, I'm not sure if I understood correctly an observation or submission which Mr. Kondle had made when one of my brethren asked him something about if would it be appropriate on the proposition as was put to council. Mr. Kondle, I'm trying to establish something. Whether at some stage you made the submission that, I think it was Judge Frank who asked the question, if there were problems with the manner in which the minister acted, would it be more appropriate to just set it aside instead of granting the relief in the form that it is sought in 1 and 2 of the notice of motion? I just want to be clear about that so that I don't misunderstand that exchange that took place.
I don't want to do an injustice to Justice Frank, but my Lord presiding puts it very clearly that really that would be the heart of it, because I understand that Justice Frank was mooting implicitly at the end was that the Section 63 decision can't stand and is set aside, but there be a remittal, whether or not there has to be a remittal, but there be a remittal as regards 30 TI for powers to be exercised according to that. And in relation to that, we exercise such rights as we may have or may not have. But the Section 63 decision should simply be set aside. And subject to taking instruction, I think that would probably then collapse what are the 2 main prayers of relief which we seek.
Thank you very much.
Yes, I think in view of that, my Lord, as long as the ministers, and the legislative imperative contained in the, in Section 30T remains intact, I believe that will be the most practical observation of the Supreme Court to send it back to the minister to exercise the powers in terms of Section 30T.
Well, doesn't that mean then you then concede Section 63 doesn't have those powers implicit in it?
Section 63?
Yes.
Yes, that was always my starting point, Justice Frank.
Just a moment, Mr. Kondle has left. I don't know whether it would be safe for us to continue this exchange in his absence.
Mr. Pels, I see you.
There's just second instruction, and I can hear and listen to the argument,
So
but we are in the court's hands.
you are comfortable with him being absent?
Thank you.
Thank you. You'll
Thank you.
Thank you very much. Yes, Mr. Patel.
So My submission, what I'm suggesting, Justice Frank, does not mean that I'm abandoning my focal point that the interpretation of Section 63 will always include in it the consideration of Section 30T.
Okay. But
So-
you say you will be satisfied with an order that the matter be, the current decision be set aside, sent back to the minister to invoke his powers in terms of Section 30T1.
Subject to taking instructions, my lord, I think that would be, is something that,
All taking instructions.
yes, my lord, that would seem to be, to me, standing as the officer of the court, I think it would be the most practicable conclusion to this matter. So,
Yes, but carry on with your argument. We take your point. I'm not so sure you can do it in view of the fact there's no cross appeal from your side, but anyway, you
yes.
can move on.
Yes, Your Lordship. So, for us, I think the strong submission that we have is that the integrity of the minister's approval for local authorities, because this is the apex court, and that needs to be clarified so that there is no confusion that there is no requirement for the approval of the minister for the transfer or alienating of land. It needs to remain intact because the consequences of that will create quite a difficult scenario for the minister to control.
Let's move on. If we accept that the minister had the power to look at the stuff and his approval was necessary, what do you say about Audi, for example?
Lordship, I don't know whether it's the acoustics of my hearing, but I can't hear.
What do you say about Audi?
Yes.
Assuming the minister had the power that you claim he did.
Insofar as the Audi is concerned, Your Lordships, we have dealt with it in our heads, but I'll just argue from what I've submitted because I believe the Lordships have considered my heads. The point that I have is that the appellant at all times was fully aware that there were objections that were made to the sale by the intended sale by the council. In fact, that was the only basis upon which the decision was remitted to the minister to exercise the power because there were objections that had been raised. It was never the case of the applicant that the municipal or the town council, the local authority, did not share those objections with them or they were not aware of them. We keep on repeating in our heads that when we look at the record, they wrote to the minister several times. Of course, the Court of Appeal, correctly so, criticized the minister for not responding to about 5 letters that were written by the appellant. And we agree with that. We can't fault that the minister perhaps should have answered. But it appeared that when you look at the sequence of all those letters and the essence of all those letters, they were pushing for the minister to take a decision. They were never saying, Minister, we have looked, you probably have some objections somewhere there, which we believe, because objections can only be that they are against the intended sale. They never said, give us those, objections so that we can then be able to address you.
But did they know there were objections? Did the appellant know there were objections?
Did they know there were objections?
Of course, that was the basis upon which it was remitted to the minister, so they must have been aware.
No, your case is that the minister has to give his approval anyway.
Yes.
That's not the basis. The question is, are they entitled to know that there are objections so they can answer to issues raised in those objections? That's really the heart of this issue. And
Yes.
that's not addressed in the heads.
It's a difficult one when I look at it, Justice Mats. And the reason why I'm saying it's a difficult one is as follows. I think it favors both us and the appellant at the same time. But quite what this court will make of it. They were aware that there were objections because the town council remitted the objections and commented, mindful of the fact that the town council was in support or is in support of the intended sale to the appellant. So they responded on grounds that also favor, intrinsically when one looks at them, at the town council submission, intrinsically on grounds that favor the appellant. They submitted all these to the minister. The appellant itself, during the engagement, either with the council or the minister, they didn't say, well, you are not ready to make a decision because we have not seen the objections. In fact, they were pushing for the decision to be made by the minister. The only time that they complained about was when they, admittedly, they went to meet the minister, and the minister said by that time the decision had already been made, and therefore he was functus officio. in his papers.
No, but that's not ad altem partem. The question I put to you, and that's at the heart of what my learned colleagues are putting to you, is did they have the right or not to know that there are objections and what was in those objections so that they could have the opportunity to deal with
Yes.
it if they were so minded?
I'm raising this just because I'm saying my submission is that they were aware that, or they should have been aware that there were objections. Because the objections relate to the process of the town council, not the ministerial process, the process of the town council. Because the council had then decided to sell the land to them, and other people objected. The town council then considered all those objections, which is a process of the town council.
But if the inference points in the opposite direction, what should we do?
Perhaps there can be a clarity of the law that even at the ministerial level, although the process itself starts and, within the town council in terms of
What
sections.
I meant, Council, is if looking at the record, we are satisfied that it's more likely than not that they were unaware. What should we do when it comes to the OD issue?
Of course, the law should be clarified that the minister should have given them the council or any further consideration of the ministers, any further consideration of the minister's powers in terms of Section 30T.
But would that be a good ground for review?
It could be, my lord, it could be a good ground, but certainly not a decisive one in the circumstances of this case, but it could be a good ground for review.
No, I'm talking about this case.
No, certainly in the circumstance of this case, my lord, I'm saying it's not decisive. It will not decisively be of the view that perhaps the minister did not do so. But of course, the order of the court can direct the minister to afford them, to allow them to exercise whatever rights that they may wish to have prior to him taking the decision contemplated in Section 30.
What facts do you, or what basis do you infer that they knew that there were objections, one, and two, the contents of those objections?
Your Lordship, I'm looking at the submission of the town council. If I can maybe deal with the submission of the town council to the minister.
But the submission went to the minister. There's no evidence that that submission went to the appellant. So the appellant had knowledge of what was said about this deal of his.
Yes, Your Lordship, as I have said, I would concede that point that there does not seem to have been a process, at least at ministerial level, when one looks at it. But the circumstances and facts of this matter, they guide the conclusion that I say, even in those circumstances, it will still vindicate the minister. And this is the reason why I'm saying.
I can sense your hesitancy, Mr. Badela, because you are concerned that if the inference is drawn and the conclusion is made that there was lack of OD and therefore the decision is reviewable, you are fearing perhaps that the result the other side seeks is inevitable. I don't want you to approach it that way.
All right, my lord.
You must approach it against the backdrop of what the earlier exchange that took place. That's 31T is binding and therefore stands. Therefore, the relief that they seek, in the form that they seek, cannot be granted against that backdrop.
Yes, my lord.
We are asking this question simply for the purposes of establishing whether there are reviewable grounds for us to get to 31 to say, we set it aside, but you are still obliged.
Yes, my lord, on the
That's
record.
the context.
Yes, that is very helpful, certainly, Deputy Chief Justice. On the record, it does not appear straightforward that there was at least audi for them to comment, not necessarily for them to address the minister, but on the objection themselves, including their contents, on the record. But I'm saying there is a bit of, at least, lack of clarity on my part as to at what stage exactly were they supposed to have been afforded the objective to, the opportunity to comment? Was it at ministerial or at town council? Because when one looks at the structure of the Section 63 itself, it says that the town council itself shall make comments. Which means that the process of hearing all the sides perhaps should have been accommodated more within the town council.
Yeah, but is that subsection applicable to you at all, even on my construction? Because you're not a Part 1, Schedule 1 municipality. So you just stuck with a general approval, a 31T approval or an implicit approval, not the procedure.
And that's why, Your Lordship, I'm saying, perhaps the Act 11 looks at it, you know, if it's approval in terms of Section 30, there could have been better guidelines placed by the legislature. But be that as it may, if there is an order for the minister to exercise the powers in terms of Section 30T and to afford interested parties such opportunity as they may wish to exercise, it's an order that I think could be helpful if directed by the court.
Yes.
Yes.
Any other issues that you feel are not covered in what you said in the exchange that took place?
Unless you just must answer another question. Those are my submissions, Your Lordships. But I stand by the submissions that I have made in the heads. I stand by them, my daughter.
Nothing was said by him, at least not orally, about costs, whichever way it goes. And
we are very courteous to each other, but we will leave that heavy task to the court. We stand by our heads of arguments. I'm sure each one of us has requested we understand that the court will follow the court's Lordships. And that's by submission, that if we are successful, then the court should follow the court.
Thank you so much.
As it pleases you,
Thank you very much, Mr. Patel. Mr. Gondi, to reply?
Thank you, Deputy Chief Justice. In my family, like my friend's family, we never talk about money, which is why we didn't refer to costs before. We would respectfully submit that it's simple, that costs follow the result. If we succeed, we say that the importance and significance of the matter have justified the incurrence of, reasonably justified the incurrence of 2 counsel in this court. As regards the court a quo, only 1 counsel appeared on our side, so we wouldn't be asking for a different order in that regard. The debate between the bench and my learned friend has sharpened the 2 halves of the case of which we spoke at the outset, the Section 63 problem and the Section 30 TI problem. We respectfully submit that the short point, particularly picking up on what Justice Frank was putting to me earlier, is this, that the minister did not plead and say, I'm acting in terms of 30 TI. He has a power under 30 TI, arguably, which has to be fought and dealt with. Had he pleaded and relied on it, then it could have been dealt with on its own terms, which would include an attack on it. The bottom line is he didn't. At the moment, then, Section 30 TI exists, it stands in law, and it would be understood, as it were, in the circumstances. If the court were to direct, it wouldn't have to direct because it would follow ex lege. If the minister says he has that power, then you'd act under it. But the court would, as regards 30 TI, say, it's not in this case. You didn't say that you acted in terms of it. We, however, read the statute books. We see that it stands in the statute books and that in its terms, without expressing any view, we would ask you on the constitutionality of it, because it's been touched upon, but without expressing any view on it, it is remitted to be dealt with as regards 30 TI. We must all, the chips must lie where they fall. It may be that that sense prevails, and after 8 years, and having decided how many cars are left in the rally, it is decided that, as the town council then was asking, let's just get on with it. So 30 TI, we respectfully submit that we for ourselves can't have it both ways. We've said the minister didn't act in terms of it. Unfortunately, it crept into the case, as it were, through the notice of motion, where predecessors have ambitiously said 63 and or 30 TI, and we can't have it both ways. As regards Section 63, my Lord Presiding and other members of the court have asked the central question: what is the court to do with the minister's decision? Is it to be left standing, or is the correct decision that the High Court should have granted that it's set aside on review? My Lords, our learned friend very elegantly paraphrased and filled in with Prattley's putty some of the missing bits in the minister's decision. So we've already taken you to it, and he then himself referred you to it at page 59, I think it is. And we would ask you just to consider, in looking at it, the significant aspects. He has taken a decision which stands, unless it is set aside, that the council must re-evaluate the bids. And as members of the court have probed, that means all the bids, dead, buried, and otherwise, on clearly determined valuation measures. My Lord Presiding asks, what does that mean? Nobody knows. The council doesn't know. And carries on, and spelt out evaluation criteria. Well, what does that mean in contradistinction to the first phrase? Clearly nothing. It's just add-on. And then it hasn't ended yet. As well as following the laid-down governance procedures and approval structures in council. And that is pregnant with the possibility that the council, if that decision stands, then is supposed to get into the evaluation of the dead, the walking wounded, and maybe mouse still in the game. But secondly, it must follow the other laid-down government procedures, etc. We don't quite know what that means, but it sounds very much to me like start again. So we respectfully submit that this decision, that's what it means. Now, how is it defended? That I took you to earlier. I took you to the passages where the minister says, read my lips. There is one thing, one important thing, and that is price. And I showed you the passages where he does that, and he determines it on that basis. And you heard our earlier argument. We had noted that our learned friends' heads of argument, almost to a word, replicate the heads of argument in the Court of Appeal. In the High Court. We were intrigued as to see to what extent he would resist what is the simplest way through the case, which is the Audi point. And that is why deliberately we've said our written argument stands, and what I'm going to say is certainly no amplification of it and no ambush of my learned friend. The crucial thing is what my lords ask. My lords Justices Frank and Justice Smuts. That is, what does the record show on the Audi point? It's actually very simple. There are really, at page 22 in volume 1, where the complaint is set out, and you will find each of the pertinent complaints there, 50.1 and on, covers each of the points that my lords were putting to my learned friend, that the applicant wasn't provided with copies of the objections, or at least advised of the import thereof, wasn't given any information, wasn't given an opportunity. You will find each one admitted at page 205, line 30. Forgive me doing what Justice Moritz rightly never liked, but someone has dispossessed me of my water. And my lords, may I say, apologize also when I absented myself earlier. It was to take an important instruction. I do apologize. I understood that my lords would understand that as why I was leaving with my instructing practitioner. Now, my lords, then the simple fact is, there was a travesty as regards the process of the minister's decision. It's just a non-decision. And simply on that basis, it can't stand. We have exercised my lords' minds because we know that my lords like mental exercise and have very little to do with one's lives, but we've gone to all the other issues to cover them as they've arisen. But with respect, the landmine under the case is that the decision can't stand. If the minister in circumstances of this says, yes, I admit that I didn't do any one of these specified steps, and therefore the decision can't stand. So we respectfully submit that the answer, the case boils down to this, that the Section 63 decision can't stand on the simplest basis, which with respect hasn't been answered with reference to what's actually on record. And secondly, then what lies still like a semi-submerged crocodile is the Section 30 power. And that must play out. And either we get to shoot the crocodile, or the crocodile gets to do something to us, or one hopes that actually there might be some level of engagement which would mean that there is in relation to this a reality, as regards which my lords would not have not noticed that the application in the High Court was served on each of the suitors, the jilted suitors. Not one came to court with an attack on the town council process or anything else. Each one decided to accept effectively the outcome in this matter. They put their money on the red or the black, and as that regard, they haven't brought a review within 7 or 8 years. So what one is left with, we respectfully submit, would be the setting aside of the minister's decision, the fact that there is no review of the town council decision before court, that the jilted suitors have been given far more Audi than we were, and they haven't come to this particular party, nor did they start another party in the form of a review. And the minister would be left like a wicket-keeper with his Section 30 power, which then would have to be exercised. We respectfully submit then that if that approach is followed, the correct order on appeal would be to set aside the decision of the minister of 9th March 2018, and then the court would decide whether or not ex lege Section 30, good or bad, applies, or whether the court pertinently says we remit to the minister to deal with in Section 30 without expressing any view on the constitutionality of the provision or in relation to its exercise or such wording. So the minister didn't take it that this means a shoe-in, a green flag to do as he likes under that. And my lord, if we succeed, as we respectfully submit we should, in setting aside the decision, we are substantially successful with the core relief before this court, and we would ask then consequentially for the costs. Thank you, my lords.
Well, thank you very much, Mr. Gondlet. Both counsel, thank you for your submissions, both written and oral. Judgment is reserved.
Correct.